Can everybody hear me okay? I'll try and tone down my Welsh accent, okay? Bits of complaints, my accent is too strong. Sorry. Okay, right now, I was invited back. I touched on the last time the concept of identity, and this, most of the stuff that people talk crap on the internet is about the concept of identity and the person, and they go into all sorts of routes to go on it, right? Anyway, I'll try and bring shine some light on that with some facts, rather than sort of the usual esoteric stuff you get in the net. Just going on to briefly what Lance said earlier on there, if there's no remedy in the courts, I would wholeheartedly 110% agree with that. The courts, as far as I'm concerned, according to my research, are not there for us. They're there to control us. My wife last week says, have you seen this video? Because we don't watch TV in our house, we're on YouTube. She was watching, and it was a
Skinny fries?
Skinny fries? Anyone for skinny fries?
Well, you don't need them.
Right. Yeah, so she said, have you seen this video? It's about European Union. And she says, are you aware how they are not liable to the law? And the European institutions, the commissioners, the MEPs, they're above the law. They're actually exempt legal and criminal prosecution. Now, I'll cover the levelers. I'll just a little bit. I'll try and cover a lot of subjects here, but I'll do it very shortly, right? We fought a civil war to make the government accountable. Man, dog, and everyone else included with it, to be accountable to us, the people. We are sovereign, and we've forgotten what the civil war was fought for. We fought a civil war to get rid of the divine power above us, dictating to us, so that we own the land. We are the sovereigns. Not the king, not Parliament. Parliament merely represents our sovereignty. It's a gift from us, a grant from us. In Scotland at the moment, there's some friends of mine, very good people, and they are currently parked outside the Scottish Parliament just now, facing an eviction warrant. Now, we spent a lot of money building this fancy monstrosity of this replacement occupying Parliament, and I will use the phrase occupying Parliament, it's not sovereign, on the previous parliamentary territory, and we found out that the millions and hundreds of millions of pounds that was spent building this monstrosity has been sold to a private property owner for 20,500, I believe the figure was. Okay, that's what public money seems to have gone to waste. So anyway, papers were served on them to move their vehicles, a warrant of eviction, Scottish law, a warrant of eviction to move their vehicles. And they said under no uncertain terms, as men and women, go f*** yourself. We are the people. This is our land. Who are you to be evicting us from our land? So there's a test in Scotland at the moment, and the law going through the law courts just now, right? And these guys are asking for your help, right? Who is sovereign? The people or Parliament? This is revisiting what the civil war was never resolved. We settled in a period of peace through fear, right? In a period of peace, they need to kick us off. In England, your Parliament in England, the one that's governing me at the moment, thinks it's sovereign. Is it bugger sovereign, right? You read a lot of stuff on the internet written by these very eloquent American gentlemen, okay? Most of them were Freemasons and stuff, but just want to read you something here. To every individual in nature is given an individual property by nature, not to be invaded or usurped by any. For everyone as he is himself, so he has self-proprietary. Means you own yourself, self-proprietary. Else could he not be himself, and of this no second may presume to deprive any of without manifest violation and affront to the very principles of nature and of the rules of equity and justice between man and man. Legal's not mentioned in there. Mine and thine cannot be, except this be. No man has power over my rights and liberties, and I over no man's. I may be but an individual, enjoy myself and my self-proprietary, and may right myself no more than myself, or presume any further. If I do, I am an encroacher, a trespasser, and an invader upon another man's right, to which I have no right. For by natural birth all men are equally and alike born to like propriety, liberty and freedom. And as we are delivered of God by the hand of nature into this world, everyone with a natural, innate freedom and propriety, as it were writ in the table of every man's heart, never to be obliterated, even so are we to live, everyone equally and alike to enjoy his birthright and privilege, even all whereof God by nature has made him free. And this by nature everyone's desire aims at and requires, for no man naturally would be befooled of his liberty by his neighbour's craft, round about us now, or enslaved by his neighbour's might. For it is nature's instinct to preserve itself from all things hurtful and obnoxious. And this in nature is granted of all to be most reasonable, equal and just, not to be rooted out of the kind, even of equal duration with the creature. And from this foundation or root, all just human powers take their original, not immediately from God, as kings usually plead their prerogative, but immediately by the hand of nature, as from the represented to the representers. For originally God has implanted them in the creature, and from the creature those powers immediately proceed, and no further. And no more may be communicated than stands for the better being, well, or safety thereof. And this is man's prerogative, and no further. So much and no more may be given or received thereof, even so much as conducent to a better being, more safety and freedom, and no more. He that gives more sins against his own flesh, and he that takes more is thief and robber to his kind, every man by nature being a king, his priest, and his prophet, in his own natural circuit and compass, whereof no second, no other person, may partake but by deputation, commission, and free consent from him whose natural right and freedom it is. Now I could go on with this. Has anyone heard that before?
What is it? What is it?
I'm about to tell you. There's a chap called Richard Overton, one of the Levellers. Now the Levellers have been politically hijacked from actually what they stood for. They stood for individual. For anyone who tries to tell me Levellers are representing communism society, does anyone read any communism at all in that? No. They were proto-libertarians, if you like, individualists, whatever you want to call yourselves, right? This is a chap called Richard Overton, 12th of October 1646. He was actually jailed in Newgate Prison by Cromwell in the Parliament because he said the army was fighting for our sovereignty, for us to recognise sovereignty, not for a king or for a Cromwell or the House of Lords to steal that sovereignty from us. This is ours. And he went to jail and prepared to die for it. And it's a long story, it's a good story, but the women of London wore pea green sashes, sea green sashes, and marched the streets of London demanding he be freed. Okay? We need to get there, we need to get this anger back again. It's a controlled anger, outrage if you like. We need to get this back. Okay? These guys are nothing we are facing now is new. These guys were facing it, okay? In the end, what it did was... Sorry?
It's the same thing we're facing.
Exactly. Levellers. Read up on the Levellers, guys. John Lilburn, hero. Richard Overton. These guys were heroes. And they were, if they had managed to achieve, what they were trying to do was say, this is not what the army was fighting for. What this bastard creation you've created is not what we were struggling for. And all these backroom deals you're doing with the money men and the banks and the lenders is undermining what people fought and died for. And the English Civil War, I call it the English Civil War, was the Scottish Civil War, which is even more brutal, which people don't know about at exactly the same time. Okay? And I'm descended from Covenanters who were butchered en masse. Because we stood up to we stood up to these guys, all of them, and said no. Yeah? We individually, from their point of view, is that we speak to God. We don't need any middleman. We don't need any governments. We don't need queens. We don't need bishops. We don't need any of these fancy people with their fancy books. And we, the highest authority you have, that I have, is my conscience. And my conscience is driven by myself. And if you believe in the great creator, by the great creator, no one else can dictate your conscience to you, okay? That's the best and strongest argument you can have. Okay? So there's, I would strongly urge, it's called An Arrow to All Tyrants. I would urge you can get it online, and then that will lead you down a really interesting path with the Levellers, okay? Don't fall for the political shenanigans, try to steal what these guys have done. What happened in the 1800s, they developed a new level of, which was proto-communists. But these guys were standing for individual rights here, and that, I've said that deliberately. So we've set a basis here. We are picking up, we stand on the shoulders of giants. These guys were phenomenal. We're minnows compared to these guys. We're standing on their shoulders now and picking up the, I won't use fight, I won't use struggle, the, I don't know, campaign, if you like, to assert ourselves as the sovereigns of this country. Okay, because at the moment we're sold out. Now, on the back of this, he closes off the arrow to all tyrants. And this was a letter he sent to the House of Lords. That's what he called an arrow to all tyrants. He called them an arbitrary bunch of toe-rags, essentially. But at the end of it, he finishes off by saying, and let even the saying of the Lord, and I'm not religious, I'm not religious, okay, but I'm just highlighting something. Even the saying of the Lord, with which I close this present discourse, close with your heart and be with you to the death. Leviticus 19:15, and Leviticus is the law book of the Bible. This thing here, yeah, it's the law book of that, yeah. Leviticus 19:15 says, "Ye shall do no unrighteousness in judgment. Thou shalt not respect the person of the poor, nor honour the person of the mighty, but in righteousness shalt thou judge thy neighbour." Okay. Now, it's an interesting little term. I'm about to show you a little demonstration how you can play with words here, how you can water things down. So this was the King James version of the Bible, and it talks about you should do no unrighteousness in judgment. It means you should be fair and impartial and offer proper judgment. Yeah, as a proper judge, yeah. Not many of us see that in the court. Thou shalt not respect the person of the poor, nor honour the person of the mighty. What that means is you shall not distinguish one man or from another. It doesn't mention corporations in there because they didn't exist at the time. But thou shalt not, given the person who they are, you should not give them any standing. It will be equality of arms in the court, and that's what that's saying, equality of arms. And our legal system is based on this. But in righteousness shalt thou judge thy neighbour. And what's saying, you shall be judged by your own judgment as well. Okay, so, but interestingly, if you look at how they've reworded this recently, so I'm looking at this going, why is it called it thou shalt not respect the person of the poor, not honour the person of the mighty? Why not just the poor and the mighty? Why bring in person there? Yeah? So you tend to follow your nose. The New International Version of the Bible, this is all the versions of the Bible that's out there, by the way, just to show you how words can be manipulated. The core of our establishment, if you like, in the UK is this thing, right? But that's only some of the translations of that one single sentence. Okay, that one verse, right? The New International Version says, do not pervert justice, do not show partiality to the poor or favourism to the great, but judge your neighbour fairly. That's their view. King James Bible, you should know, King James Bible brought in the concept of personhood. Right, be aware of that. King James has brought in the concept of personhood. It was a very legally technical document designed to do that. Okay, you should do no unrighteousness in judgment. Thou shalt not respect the person of the poor, nor honour the person of the mighty. Now, interestingly, I wrote to Church of Scotland. My background is Presbyterian, hated by establishment down south, because we tend to go to everybody, right? I wrote to Church of Scotland. It goes, where are you guys? They issued this statement a few weeks ago, and it was talking. It was last year, and they were talking about trying to get the terminology right. It was the respect for the person as the fundamental to the legal system. Well, that seems to massively deter from what Leviticus is saying. It's saying, don't respect the person in there. And why are they talking about the person? Why not man or woman? Because I believe the Bible says that we were created in the image of God. So I wrote to Church of Scotland for guidance from my superiors there. And I said, why using the name? Why using person? Why not men or women? Person's not to do with the Bible. Men or women are Bible. And they come back and said, it served as inclusive. Right, well, you know, after I started throwing things around and swearing at them, I responded back by quoting Leviticus and saying what you're doing is betraying us. At a time when we need these spiritual institutions, whether they agree with them or not, I don't care, Church of England has completely sold us out, Vatican, God knows what they're on, Lord knows what they're on, right? Church of Scotland, they're retreating into bloody PC correct land, right? And by doing so, they're falling for the crap and they are selling out, okay? So, bottom line is, I don't believe we've got any... The last thing we've got is spiritual leaders. We don't have any spiritual leaders. You're saying about judges been appointed by Archbishop of Canterbury earlier on there. Correct. So shouldn't they be able to be judged? Anyway, so that's that. Right now, I will quote an American gentleman because sometimes you come across something which is so wonderfully... I say I'm not a bright guy, but I read lots of bright books written by bright people, some of it sticks, right? And I can't emphasise enough people need to read books. This is a book called Fruit from a Poisonous Tree, which was recommended to me by Melvin Stamper. And he says in that, this was from a Supreme Court case from, I'm not quite sure the year, but anyway, in a government of laws, existence of the government will be imperilled if it fails to observe the law scrupulously. Our government is the potent, the omnipotent teacher. For good or ill, it teaches the whole people by its example. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself, and it invites anarchy. The time in which Justice Brandes spoke was a simpler time, and the government had not broken the chains with which the Constitution bound it down. Unfortunately, the federal judiciary has opted out of the separation of powers doctrine of the Constitution. Seems happened here.
Yep.
And now has become self-regulating. The courts do not maintain their independence as a judiciary. Without constitutional authority, the system elevates judges above the law. The courts are no longer our courts of justice or our bastion of freedom. With the passage of the War Powers Act 1933, and we can go into, we've got our own laws here. Defence of the Realm Act was a DORA. It was an absolutely blistering one. They have become the executive's tool. So the courts are now the executive's tool. I agree 120%. The judges are little more than organised crime families. They have invaded the people's court and now only impersonate and give lip service to justice by exchanging obfuscation and sophistry in place of a justice system void of any form of judicial integrity. Enforcing judicial standards on judges under this system is impossible. Even though the court has rules, the judges make up their own rules as they go. I've experience of that. Or break the rules with impunity wherever it is convenient for them to do so. How can you take a judge to court when the judges control the court and have granted themselves immunity from prosecution? How do you call the police when it is the police themselves who are breaking the law? And this morning, just catching the news this morning, one officer investigating paedophile crimes in a metropolitan city has been arrested for what? Making bloody kiddie porn films. Right? We've just had 3 senior police officers, from what I gather, been arrested for fiddling the books to do with the police federation. How can we trust these people? They're not even police themselves. Did you know they can't do an audit on the police federation because individual divisions around the country refuse to divulge their accounts and be audited? And we're standing up in court answering for a couple of £100. Anyway. I've nothing against individual police officers, and like when I joined the army, I joined it for the best of intentions, to help the weak, you know, protect the poor. I did it for all the best intentions, yeah, I'm sure most police officers did. However, the guys running the show are as corrupt as the day is long. They have sold their souls for a pottage of gold. Right? The people have learned their lessons well. They follow by example. An example of the courts and the criminal justice system has led the people to behave criminally, just as Justice Brandes predicted. Now, I don't think anyone here would disagree with that. Now, I'll briefly go on to identity presumption. I'll try not to keep it too long. This is really important. This is really powerful stuff, right? Everything we're doing is based upon the presumption of certainty. Under trust law and under contract law, you can only form a trust or form a contract once you've established a certainty. They can only be certain if they're based upon certain foundations. Make sense? I'll cover that in a second. I'll go into the details on in a second, right? rather than fighting the branches halfway up a tree, I want to go for the actual base of this edifice that's been created around about me, around about each one of you. Yeah, this is a personal, individual thing you have to do here, and you have to ask, who am I? Because every time you get a letter, at the very top of the letter, under their logos and all the usual crap, it says Mr. John Smith or Mrs. Jane Smith or Miss Jane Smith or whatever, and that is offering you a presumption of certainty of identity. Okay, they need you to assume that presumption. Once you've assumed it, you are screwed. Trap. Now, there's another good book I would recommend, given to me by a good friend. It's called 4 Arguments for the Elimination of Television.
Oh,
The problem is we're dealing with people out there who don't listen to us, because where are they getting information from? I had the conversation with a guy last week there. Yeah, it's bollocks. I says, do you like, I just picked it out at random, Tony Blair, do you like Tony Blair? Oh, blah, blah, blah. And he had loads of opinions on Tony Blair. It was irrelevant what they are. And I says, have you ever met Tony Blair? Do you know him? No. So how can you have any, you know nothing, all you know about Tony Blair is what you've read in the newspapers or what you've seen on television. The same as your neighbour, the same as me, the same as everybody else. Tony Blair might not even exist. We don't know, right? Because what we've got is what's called, so I'll just refer to this. What's called is unity, and the TV is designed at a scientific level, and this was written in 1978 by an insider, an industry insider, right? It creates unity. It's the illusion of shared experience.
yay, that's it.
Okay? So remember, when you're saying, who am I, what am I, you've got to be aware that you've been heavily influenced by a lot of external stuff you take as being facts, right? I deal with facts. All I deal with is facts, right? And it's difficult to do because you go, yeah, I hate him, or I hate her, or oh, I love him, or oh, she's nice. But remember, the pretty girl standing there looking over, she doesn't look at that first thing in the morning, because this is what the TV presents to us, right? So this is a very good book, right? The expropriation of knowledge. So it's a shared knowledge, a shared experience. And also, if you go to work in the morning with your mates, you talk, well, what have you got to talk about?
Yeah.
You were at home, he was at home, you get different experiences, so you talk about the football or the rugby, or what was X Factor last night, or the boxing match, whatever it was, you know. And you talk, and you have a conversation with something, you were not there. Yeah? And it's filtered before it hits us as well. So, a very good book I would recommend, 4 Arguments of Abolition of Television, the Elimination of Television, written by an industry insider, and it's gobsmacking. It's common sense to us. You read it and go, yeah, I know that. But it lays out the argument for you. For new people, that'll be shocking, because they're addicted to their televisions. It's an addiction. Right, so that's who you are, is influenced by external sources. It's your family around about you, by the TV, by the media, by the internet, by you bunch of loons out there, and this loon standing up here. It's up to you to sort your own life out. Nobody else is going to do it for you. I don't give a shit about any of your lives. It's up to you to sort your lives out for yourself individually, yeah? And disappear into the private. So, you've all heard of the term legal fiction. Right, okay. Legal fiction comes from the Latin, and you have to go back into Latin, and Latin's a real interesting. Going into Roman law is real interesting, especially if you go back into Roman law to do with occupied territory, which we are. And that's another talk we'll do if you want to know occupied territory. I'll prove to you we're on occupied territory. You are under occupation. That's why there's no sovereignty, that's why there's no constitution. We're under occupational administration, and have always been so. It's called fictio legis. I don't do Latin, I don't do good Italian accent. Fictio legis, so it's a fiction, it's a creation of the law. And some definitions, I'll just go very briefly, right? A legal fiction is created for the purpose of promoting the ends of justice. That's it. So they have to create this fiction to promote the ends of justice. There are some situations where you can understand why they've got to do that. However, you know these guys, you give them half an inch, they'll take 3 miles from it, is what they've done. They've now used that, instead of promoting justice, to get justice, they've now used the legal fiction to enslave us. Okay, and impose a tyranny on us, rather than a justice system. I go to court, I want justice, I don't want to be imposed on. A common law, for example, would allow a father to bring a sword against his daughter's seducer based on a legal fiction for the loss of her services. Okay, that's currently case law. And these fictions, this comes from William Blackstone, and these fictions of law, though at first they may startle the student, he will find upon further consideration to be highly beneficial and useful, especially as this maxim is ever invariably observed, that no fiction shall extend to work and injury. That's a big statement. Its proper operation being to remedy a mischief. So they can only create, they can only use a legal fiction to remedy a mischief, or to remedy an inconvenience. That's the only time they can create a legal fiction. Be aware of that. This is William Blackstone. Read that again, it's so big, right? That no fiction shall extend to work and injury, so a fiction can't be used to injure you, and its proper operation is to remedy a mischief or to remedy an inconvenience that might result in a general rule of law. So the true is this, that in fiction, juris temper, subsequent equus. Anyway, so you can see what the legal fiction has a purpose, very clearly defined, narrow purpose. Herbert Broom says the fictional juris is defined to be a legal assumption. A thing is true which is either not true or which is probably false as true, and the rule on this subject is that the court will not endure that a mere form or fiction of law introduced for the sake of justice should work a wrong contrary to the real truth and substance of a thing. So saying unless you present a real truth, they can impose a fiction on you. Okay, I'll give you some truth.
But who decides what a truth is in the system?
A truth is where, in law, if I say this is a fact and you say I agree to that, it becomes a truth.
Try that in court.
But that's the legal stance on it. Yeah, it probably doesn't work in court because they just make up as they go along. If two parties agree a fact, the maxim is it becomes a truth. Yeah. Okay. Now, well, again, in courts, weird and wonderful things happen in courts. They break their own, they just make up as they go along. Right. So. This should be an overhead. We have overhead facilities here, so I'll just have to read it out for you. Right, this is a presentation I did in October 2013. I've updated a little bit, and it's called Mistake and Uncertainty of Identity Capacity. Council tax, I would kill council tax there, okay? Right, mistake and uncertainty of identity and capacity. Now I stumbled on this. I was telling everybody, jump on this, guys, and nobody did because people were too busy fighting, learning the law, and learning the rules, and learning the procedures, and being clever, right? You can pull the tree down by removing that certainty about it all. Right, so useful definitions, and I'd see a lot of people confusing these things. Rescind means to annul or repeal. Annul, to make or declare void or invalid, as a marriage or a law, to nullify. Nullify, to render legally void or no effect. Repeal, to revoke or rescind, especially by an official or formal act. Revoke, to void or annul by recalling, withdrawing or reversing, and to void means not legally binding. Okay. What is a mistake? Halsbury's Laws of England. This is, you can go and quote that in court. Halsbury's, right? It's English. This is in 2010. Mistake has long been considered to have an important impact on moral responsibility. It is also important in relation to questions of legal responsibility. This title deals with the consequences of mistake, whether of fact or law. So you can make a mistake in fact or a mistake in law, as a ground for relief. And all this is about getting relief. The effective misrepresentation, so blah blah blah. Misrepresentation resulting in the mistake of one or more of the parties to civil litigation is principally dealt with elsewhere in this work. Right, I'll cover that, right? As same with so I'm looking at misrepresentation. Okay, from my point of view, now you have got an obligation to factually present yourself to outside world correctly. Because if you don't, you're just wrongdoing. Yeah. If you knowingly present yourself to outside world, otherwise, and it actually factually is, you're creating a wrong and potentially leaving yourself liable. So I try at all times to present facts to people. So misrepresentation is one of them. I would hate to misrepresent myself to you guys. So misrepresentation is covered under equity, is covered under legal system, and is covered under common law separately for different reasons. Okay. People talk about fraud. Start looking at negligent misrepresentation. Fraud requires you to prove intent. Negligent misrepresentation requires you just to prove negligence and misrepresentation. Okay. A misrepresentation is a positive statement of fact which is made or adopted by a party to a contract and is factually untrue. It may be made fraudulently, carelessly or innocently, where one person makes a misrepresentation to another which has the object and result of inducing the representee to enter into a contract or binding a transaction with them. The representee may generally elect to regard the contract as rescinded. Okay? So if you can say, I signed that or agreed to that and it was factually untrue, right, that is, the relief there is to get it rescinded, get it struck out and take it back to where you were before. A common law, the relief afforded by the court to a representee as such does not extend to the award of damages for loss suffered by him entering into a contract or transaction unless he can further show the false representation was made fraudulently or negligently. Stu, what is it? That's just happened to you, isn't it? Confirm what
I was thinking that.
by statute, however, what did the judge say to you?
Tyranny or order. Basically, tyranny or anarchy, you know, it's the difference between the two.
Yeah, so I just want to clarify exactly what the judge said to you. This is important.
He actually said to me, he said to me, money is a fiction. Doesn't matter if it's from Ware Bank or the other side, he said it's a fiction. He said it's the difference between order and anarchy. He said it might even be said it could be tyranny or anarchy, but we go with tyranny because that's the rule of law.
Whoa!
Did they catch that, yeah?
And that's in the Court of Appeal.
You imagine I responded to that.
Whoa!
So the judge has admitted that tyranny is acceptable. Can I just go on that basis, right? Universal Declaration of Human Rights, okay, 1948. In the preamble, maybe people have heard of this. You've heard of lawful rebellion, and you'll talk about the Constitution and stuff, right? Did you know there's another lawful rebellion you can call? And one is, whereas disregard and contempt for human rights have resulted in the barbarous acts which have outraged the conscience of mankind and the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want has been proclaimed as the highest aspiration of the common people. To be compelled to have recourse as a last resort to rebellion against tyranny and oppression, the human rights should be protected by the rule of law. All the human rights stuff comes from that.
What is
If the Universal Declaration of Human Rights. You can buy that nice little book, it's somebody in America does them.
53 or 4 is it? What's the date of that?
48, 1948.
48 is it?
This is
The
what...
funny thing is, most of those are actually printed in China.
But that's printed in numerous languages. It's a very short document. That's how big it is, right? The rest of them are in all different foreign languages, so the whole world can read this, right? This is what human rights has to comply with. Any discussion of human rights, this is the intention. Okay?
What date did you say that?
1948. Universal Declaration. If you just type in Universal Declaration of Human Rights.
48.
48, yeah.
But the
Wow,
rights,
I've never heard of that, right?
but the rights of a man and a woman are printed on your heart.
Yes. And that's another, your conscience is higher. This is someone else's conscience.
That's a humanitarian,
Yeah.
which is a colour of law.
Yes.
You is a colour of
Yes.
law.
And what they're doing is trying to bring something into, because what happened in the Second World War and the horror and killing.
But the same mindset is still in control.
Yes. Because the very people, 1998, the United Nations was taken over by international communists, right, and taken over by corporations, okay, who wanted this one world, one control. They're obsessed with controlling everything we do, yeah. They took over, and in 1998 there was a bunch of dissenters within the United Nations, and they produced a document. It's called the 1990. If you just type in United Nations 1998 Declaration, and the terminology of it is called, it's a long title. The rights and protection for the rights and fundamental freedoms of advocates for fundamental freedoms and human rights upon the state and organs of the state. You have to read the document, right? If you just type in 1998 UN Declaration, there's only one declaration. And what they said was, I read the background to it, and these people are saying, we're screwed now. The United Nations has been taken over, it's been subverted. Gen 21 being part of it, has been subverted now by forces bigger than us, and we're giving you this parting gift before we go. So please go for it, because if you identify yourself to the other side, I don't mean the other side, if you identify yourself to those who are obliged to adhere to this as an advocate of fundamental freedoms or of human rights and human rights, they must respect you, assist you and protect you if you properly identify yourself. That's why we identify ourselves as advocates of fundamental freedoms in our formal documents, and put them in notice. You have an obligation under law, a duty of care to protect, assist and remedy me. Okay, that's the big one.
Can I just say Bob, that I've used that because,
Yeah.
I mean, it gets rid of the Mackenzie Friend situation.
Yeah.
Really, you know what I mean?
Yeah.
You're an advocate for fundamental freedoms and they ended up talking that years ago and it's part of
You can put a judge in notice, get a judge working for you. I've done that. You judge, you're obligated to that, yes. Well, there's other ways of doing it as well, but that's just one. Well, in that case, protect me. I'm an advocate of fundamental freedoms. I'm here to serve the same purpose as you are, to end slavery or whatever it is you're going to do. I'm a slavery abolitionist. So therefore, we're on the same side. I need you to protect me. And we had a judge stand there like, flapping her lips in the air, right? Because you've suddenly, the judge is trying to be impartial. You've dragged her in. You've got an obligation to protect me. Okay, anyway, blah blah. So identity precipitancy, I'll blast through this, it's quite technical. I'll give, Paula's got a copy of it. If you want a copy of this, I've already done it. Everything you need to know is in there, yeah? That's
I'm
Paula.
not going to do anything else for anyone, sorry.
Okay.
Nasty stuff, no.
Okay, well in that case, you can contact me, I'll give you my email address afterwards, yeah? Where fraud can be shown, this against misrepresentation, where fraud can be shown by a representee who has in any way altered his position for the worse, whether by entering into a contract or agreement or transaction, the consequences of it, such damage as he may have suffered, in accordance with the general principles governing the award of damages, for recovered for the representer and the claim for deceit. The Deception Act is no longer with us. Funny that, isn't it? 2006, 2005, they took away the deception. General relief is by way of rescission or damages, so it's taking things back to where they were before. So the parties split up and go back to where they were before, or damages, but not both. However, where the representee has not only entered into a contract, a binding transaction with the representative. Right, I'm not going to go into too much technical detail here, right? You'll thank me for that, right? There is a Misrepresentation Act 1967. Be aware of that. But if you misrepresent, you're breaking the law. You've got an obligation under law to factually present yourself correctly. I've explained what the fiction is, the legal fiction is, right? I'll go into identity in a minute, your identity, the identity. It seems that where misrepresentations are not fraudulent or deemed to be fraudulent under the Misrepresentation Act, the representee may recover an indemnity appropriate to relieve him from consequences and obligations of the contract that is set aside. Right, so just be aware this covers all the jurisdictions, okay? Mistake, you can say, I made a mistake. Last week, or this week you said the same thing, didn't you? And the judge accepted that. Plea non est factum. A plea non est factum is a well-established principle of law of contract in the absence of fraud or misrepresentation. So complete innocently, right? You bumbled along, you're non-competent. Non-competent means not trained. Incompetence is a different thing. Non-competent, you weren't paying attention, whatever, right? You're asked to sign something, you didn't read the document, whatever, or you couldn't read the document, and you signed it, right? There's, under narrowly limited circumstances, there's a defence of non est factum, which means it is not his deed. So it means I didn't know what I was signing. Right? You must read the documents. They must have you read the documents before you sign them. Okay? So plea non est factum. Grounds for relief due to mistake. Mistake is a ground for relief under common law. The common law, there's four. In claims to recover money paid under a mistake, in claims to recover property which was prevented from passing by reason of mistake, in claims to recover damages in respect of a mistake induced by fraud or non-fraudulent misrepresentation, as a defence in claims of contract where a mistake of fact was of such a nature as to preclude, and this is the big one, preclude the formation of any contract in law. I'll read that again, as a defence in claims of contract where a mistake of fact was of such a nature as to preclude the formation of any contract in law. You can demolish a contract, you can dissolve the contract, you can dissolve the trust by saying, I'll give you the test of the trust in a minute. So it's an equity, well, mistakes big in equity. Equity is the highest form of what we can call law, but equity is equity, right? An equity mistake is said to relieve a much wider range of cases in the common law. It includes rectification of documents which do not accurately record the transaction concerned. So equity can change a contract. Yeah? The judge or the master can change a contract. A defence to some suits for specific performance of contracts. So they can compel you to perform. Proceedings to recover or regularise money paid and other assets transferred by mistake. And the so-called doctrine of proprietary estoppel. Did you all know it was an equitable? Common mistake, this is the important ones. So there's different types of mistakes. Common mistake. Where a common mistake occurs, the parties appear to be in agreement, perverted into the contract under the same misapprehension. Where such a mistake is fundamental to the contract, it may be void ab initio from the beginning. Right? So if both parties have inadvertently signed the contract, you both don't understand what you've done. Right? You've made a mistake. It just voids the contract. You both say, okay, no longer there. Right? Mistake is to title. Where there is an agreement to transfer property one from one person to another, but the buyer already owns the property, neither party is aware of this, the contract will be void at law. And be aware, here there's a technical difference, be aware of voidable and void. Right? Be aware under the system it's different, technically different things, right? I'm not doing a lecture here. Mistake as to the existence of a subject matter. The subject in a contract is the party signing it. The object is what you're signing for, the goods. Yeah. Right. The car. So in this case, right, there was a case where a cargo was destroyed. Right, it went to court. The cargo had to be disposed of, and the court held that the contract was void as the subject matter ceased to exist. So the subject of the contract, the cargo, was destroyed. It ceased to exist. The contract ceased to exist with the cargo. Okay. Mistake as to quality. A mistake as to the quality of the subject matter will not render a contract void at common law. Right. So if you say that it's you've agreed to buy a painting, if the painting is not quite what you said, it doesn't matter, that's for you to seek recompense, it doesn't void the contract, you still agreed to buy a painting. Mistake as to the possibility of performing contract. Where the obligations under the contract are impossible to form, the contract will be deemed void. Mistake in equity. Where a contract is void on the grounds of common mistake, the court will either refuse specific performance in equity, or it can grant rescission and impose terms if necessary. Mutual mistake. Where a mutual mistake occurs, there is a misunderstanding between the parties as to each other's intentions and their settlement cross purposes. When I was in Ireland, there was a big development going on, and the two big money men shook hands on a deal, and I want it in writing. I'm British, I don't do this Irish, yeah, you know, my word is my bond crap, I want it in writing. So I'm the one that's got to run the site. Yeah. Transpired, they had both misunderstood what they'd agreed, and it was good that I'd asked them to put it in writing, because this was about 20 million quid. And it ended up really messy because I asked for writing, okay? So it was a mutual mistake took place. A unilateral mistake. Now this is the one I use a lot. A unilateral mistake is where one party is mistaken, the other party knows about it and takes advantage of the error. Council tax. A unilateral mistake also negates consent and the existence of an agreement. Mistake as to identity. Where a mistake as to the identity of the other party to the contract is made, in this case law here, this is solid case law by the way guys, and it's easy, right? The contract will be deemed void, not voidable, void, if the identity of the person is central to the contract. Now what this is saying is, if I go into a shop to buy a packet of fags, the guy in the shop doesn't care who I am. Doesn't care if I'm man, woman, whatever, right? There's no face-to-face contract there. But where he needs my name, for example, signing a mortgage, signing a loan agreement, signing a car purchase agreement, something with its name, that's called a face-to-face contract. That elevates the duty of care on the parties to identify who you're dealing with. Okay? And there's 4 nice little cases, or funny, they're actually humorous. However, when the parties negotiate in person, there's a presumption that there is an intention to do business with the person in their presence. That word presumption and person in the same sentence. In which case it is unlikely that a contract will be void, as demonstrated with the case of Phillips versus Brooks, but however it can be voidable. Right, Phillips, right, Cundy versus Lindsay, 1888. Lindsay and Co were manufacturers of linen handkerchiefs, amongst other things. They received correspondence from a rogue, I love his old cases, a rogue named Blencarn. He'd rented a room at 37 Wood Street, Cheapside, but purported to be, so basically what he was doing, he pretended, he sounded like the company, he represented himself as if he was this big buyer company, everybody respected you, the buyer company, and then he ordered handkerchiefs and he sold it to him, thinking he was this proper outfit called Blencarn & Co. However, he wasn't. The judge, they took him to court and said, "We want our handkerchiefs back." He'd ordered 250 dozen linen handkerchiefs, which he'd sold on, right? The judge said they were forced to return the goods, or make good on their losses, yeah. So in that case, because they hadn't checked the identity of the party, they were forced to give, because they had identified who he was, right? Yes, he looked legit, he was, you know, as best they could check, he was right, but it turned out he was misrepresenting himself. So the judge says you weren't blatantly at fault there, so what we'll do is just return the goods and make good, and we'll take it back to where it was, rescind the contract, yeah. Alternative was Phillips versus Brooks. In 1918, a man named Mr. North, straight away, don't distrust, my name was Mr. North, yeah. Anyway, Mr. North, if there's anyone called North in the room, I apologise, entered Phillips' jewellery shop and said, "I'm Sir George Bullock." Right? You go, yeah, okay. He wrote a dud cheque for £3 to pay for some pearls and a ring. He said he lived at St James Square. Mr. Phillips checked the phone directory and found there was someone nearby that name. Mr. Phillips asked if he'd take the jewellery with him. Mr. North said he would leave the pearls and take the ring for his wife's birthday tomorrow. Mr. North pledged the ring to Mr. Brooks, limited for £350. The cheque was dishonoured, so he left the cheque behind. But don't come back, cash the cheque, right? Funny enough, boing. Mr. Phillips sued Brooks to get the ring back, right? Another rogue. The minds of the parties met, and so the decision is the judge. The minds of the parties met and agreed upon all the terms of the sale. The things sold, the price and time of the payment, the person selling, the person buying. What the shopkeeper hadn't done was checked his actual identity. He didn't check he was that name. So who would you think's liable there?
Shop.
You have got duty of care. This is another, the more recent test case cements that, which is if you're selling a second-hand car and it backfires on it, you is liable for it, right? Anyway, we'll cover that. The fact the seller was induced to sell by fraud of the buyer made the sale voidable but not void. He could not have supposed that he was selling to any other person. His intention was to sell to the person present and identified by sight and hearing. It does not defeat the sale because the buyer assumed a false name or practiced any other deceit to induce the vendor to sell. So anyway, right, the more recent one is Shogun Finance versus Hudson, 2003. There's 3 cases. This is beautiful stuff. A rogue went by a Mitsubishi Shogun, don't know why, on hire purchase. The rogue told Shogun Finance Limited his name is Mr. Patel and produced Mr. Patel's driving licence. The finance company did a credit check on Mr. Patel, finding no problems, and the rogue drove away. Another rogue. The rogue drove away. Then the rogue sold the car to Mr. Norman Hudson. Under Section 27 of the Hire Purchase Act 1964, a non-trade buyer of a car who buys in good faith from the hirer under a hire purchase agreement becomes the owner. So Mr. Hudson would have been the owner if the hire purchase agreement were valid. Shogun Finance argued it was not on the basis there was a mistake to identity. They therefore claimed Mr. Hudson for conversion. The decision was the majority of the House of Lords, and so high this case went because it's got such big implications, right? Lord Hophouse, Lord Phillip and Lord Walker held there was no contract, right, of hire purchase between Shogun Finance and the rogue, so the car was not Mr. Hudson's to do with or sell. This followed the principle established in Cundy versus Lindsay, which I mentioned earlier, that written agreements do not infer a presumption to sell to the immediate purchaser or identity of its key importance to contracting. So these cases underline how important it is, if anyone writes to you and says, give us money, you have a duty of care. It's expressed duty of care, express and implied duty of care on you to check who you're doing business with. And I started doing this with Wigan Council, read this stuff with. Wigan Council is offering 3 different names. Who are you? I'm complying with this. Yeah. 5 years later, I still don't know the answer. Right, port security regulations. Talk about the port authorities. False statements in connection with identity documents. A little story behind this. I'll give you the story. This is interesting. So false statements in connection with identity documents. A person commits an offence if, and this is the Port Security Regulations 2009, a person commits an offence if without lawful authority or reasonable excuse for the purposes or in connection with an application for the issue of an identity document to which this regulation applies or in connection with continued holding of any such document which has already been used, that person makes to any of the people specified above a statement which that person knows to be false in a material particular or recklessly makes a statement which is false in material particular. Do you understand that? Yeah, it's actually committing a crime if you falsely apply for a travel document such as a passport, right? And the facts are false on it. I've already said the legal fiction is a falsity, right? So I started questioning, why are they accepting me going forward as legal fiction, which is as every law book says, is false. Why are they allowing me to apply for this document? So then what I did was I went back to the birth certificate, give the background. I went back to the birth certificate, and its name's on there, it's white paper, blah 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 blah, right? So, I don't know, the shenanigans happen in families, as fathers, wives and other brothers share women around, and there's all DNA getting messed up, you know. So, I mean, there might have been some rumours in my family, there might have been shenanigans going on, and I thought I'll just check on this, what's the situation if this is going on in the case, right? So I'm no longer assuming certainty here, I'm presuming there might be some wrongdoings. So I wrote to the General Registry Office of Scotland, this is before you guys all pounced on it and they shut the doors, but the General Registry of Scotland confirmed, wrote back and said the birth certificate offers, I got it confirmed, offers no certainty of identity, right? Also, we are not allowed to inspect the original document, any original documents. All we can do is go through an intermediary and apply for an extract of a copy of a, so it's hearsay on top of it as well now, okay? So that thing you've got called an extract of birth registration is entirely hearsay, right? And what does it prove? One thing, that the registrar was there, because the registrar was the only person who was asked to identify himself. That's all that document proves. An event took place and that registrar was there, that's all it proves, yeah? I've got that black and white. That's how I deal with black and white. I don't go there, just waffle my lips. So I'm dealing with the other side, I just hit my bits of paper. He said this, she said that, I don't know. I'm dumb, I don't have no idea. Right, then I wrote to the General Registrar Office in England, and the General Registrar Office in England said similar thing. I then wrote to 50 embassies around the world, asking them, I've got this thing, I've got this red booklet, it's called a passport, no idea what it is. No idea, I'm a genuine, how many people in this room can tell what a passport is? You can tell me it stops you getting beat up, it stops you getting arrested, it allows you to wander around and enjoy yourself in the sun.
As far as I understand it, it's only the cover.
Yep.
The part that has the Queen's statements on, saying the Secretary of State for the Queen would allow you to pass this border with all help and no hindrance. The pages inside, the leaves inside, as far as I know, are the legal part. It's just the cover that is the passport, and it never goes out of date.
And I understand it to be a place where you can go, a document where you can go from corporation to corporation.
It's a claim of ownership of you as cattle or as goods. It means that nobody else can put another, there's already a claim on you, nobody else can claim on it. That's what it is. What it also is a licence, so if you go abroad, if you actually understand power of attorney, go into power of attorney, get another wee talk I can do, if you go into power of attorney, you'll understand that what that passport does is create power of attorney for the legal person over the wild animal, right? God's creature, whatever you call it, yeah. So if I go out there and get drunk and go, you know, breaking stuff up, that's the beast that does that. It's not the beast that he holds accountable, it's the legal fiction, the mister gets held responsible. He should be one sitting on my shoulder going, stop, 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 steering me. He's not doing his job properly. Same with the driving licence, by the way. But anyway, so one response I got back, for example, just one from Barbados. I've been advised that you should not try to enter Barbados until the question of your identity is resolved completely. If you require further advice, I suggest you contact the Immigration Department. And what I've done here is I brought leverage, because I can now say this passport isn't worth toss, right? Because unless I lie, and that Port Authority regulation says, if I misrepresent myself, that's a criminal offence. Now I'm being factually correct here, I don't know what I am. I'm a man, that's all I know. And this isn't Freeman stuff, this is according to regulations, right? All I know is, I'm a man, right? This legal, I've no idea what legal fiction is, I'm not legally trained. I can't make those legal decisions, right? So I wrote to the highest authority in the land, which was the Secretary of State. Can you give me a letter of marque along with this passport, so if I go to Barbados, I'm not going to get jailed? Because if they ask me the question, are you Mr. blah 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 blah, and I ask them honestly, I have no idea. Right, this is the question I ask these guys. If I turn up your borders with this passport and I'm asked the question, are you Mr. or you the name on there, well, I don't know. Right, 4 countries would immediately have jailed me. Right, all the countries other than the EU would have ejected me immediately, plane straight back. You're going the next plane back, right? Most of you EU countries go, yeah, come in, man, make yourself at home, because we're screwed up here. Anyway, so now I've got leverage because I can go in there and test this. So if they say, oh no, your passport's fine. And I go a fine way to Libya, or fine way then as it was, or Saudi Arabia, or North Korea, or any of these other countries with this passport, and I asked the guy at the customs, ask me if I'm Mr. blah, 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 right? He asked me a question, I said, I don't know. Any harm that comes upon me is negligence on the part of the government, because that passport isn't doing its job. So I can now test this. They know I can test this. I can go and get cases against them on this one, right? So I then looked to the Secretary of State and said, can I have a letter of marque to accompany this document? You're the legal expert. Whether or not I am Mr. John Smith, whatever, is a legal determination. I'm not legally qualified. And how many people out there say you are Mr. and Mrs. John Smith or Jane Smith? You're asked to make a legal determination. You are not legally qualified. Your answer to that should be, I don't know. That's a competent answer. An incompetent answer is yes. Right? You say, I'm non-competent, I'm not trained to make that legal determination, because it is a very complex legal determination, way above our pay grade, right? So I wrote to the top of the pile, Secretary of State. The response I got back is what I'm focusing on here. She delegated responsibility for a response to the Chief Executive and Registrar General, Sarah Rapson, I think her name was. Home Office Identity and Passport Service is no longer a ministry, right? You appear to acknowledge that you were known by these names, and so I cannot see how you would be lying when using documentation that reflects you. Now all this stuff I've talked about earlier on goes on to this one sentence. You appear to acknowledge that you were or are known by these names, and so I cannot see how you would be lying when using documentation that reflects you. I spent 3 months just in that one sentence taking it apart. She's saying something but not saying it. It's very, 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 very legal, right? What I'm trying to do is create precedent. Where I've been using this name, I've created a precedent, I've created a custom, I've created a tradition by using this name, right? However, I've talked about a mistake. I made a mistake because I'm not legally qualified. However, it's completely unilateral mistake because you knew I'm a dumbass. You know I'm not legally trained to make these presumptions, right? But you guys in government do know you're legally competent. You should have told me about this. You should have, especially when a trustee of the trust, you should have told me about this.
Okay.
So they've tried to say, well, because you've used the name of the past, you can carry on using it. Well, I know I can carry on using it. The Human Rights Declaration of Rights says everyone's entitled to recognition as a person before the law. Section 17, I think. Yeah, I know I've got the right to be recognised. I don't want to be because I don't know what it is. I don't know what you're offering me, what vehicle it is you're offering me here. So I need you to tell me. They don't want to tell us. Again, so the first part is you appear to acknowledge that you are known by these names, and so I cannot see how you would be lying. That's what I've said, am I lying? Yeah? When using documentation that reflects you. That one word reflects is a really interesting document, right?
Yeah.
Right. How many people are religious in the room? Just to, okay, I was expecting that, right? You're aware that anything in the mirror image, according to Christians, according to the Christian religion, is deemed to be evil. If it's a reflection, it's evil. It's not you. Yeah. Anyway, also it reflects you as it's not you. It's merely your shadow. It's something that follows you around. It's not you. And under Greek, the word person, persona, comes from the Greek for mask. And that's exactly what they're talking about here, right? They're saying you can continue to wear this mask. They're giving me permission to. That's fine. But I don't know what it is. I don't know who I am. I don't know what it is. I can't use this because if I say under that, yes, I am Mr. John Smith, I'm breaching, where is it? The Act. I've lost it. But that Port Authorities Act, I'm breaching it because it says I'm factually making the law. If I say I'm Mr. John Smith and I'm presenting a passport, I'm actually breaking the law according to that. Tie them up in their own mess, guys. You really tie them up in their own mess. Listen, if somebody writes to you a letter, you come back and say it's legal. You saying that I'm not legally qualified. I can't legally determine if I'm Mr. John Smith. You're the legal experts. You get a big legal team. Can you tell me I am or not? And by the way, you're carrying liability because what this boils down to is who carries liability. If they get me and you and everyone else to say I am Mr. John Smith, Mrs. Jane Smith, Miss Jane Smith, whatever, if we assume that, we're also accepting full liability for it. So what you must always do is make sure that I never make a statement, ask questions and act upon advice given. I can't emphasise that enough, right? Ask, I don't know what to do here, guys. Remember, there's a trust going on. We're the beneficiary. I've been asked a question here, what do I do? Or even if I'm the trustee in the trust, ask the senior trustees, I've been asked a question, I don't know what to do. I need guidance. That's how a competent trustee would conduct themselves, we're asking for guidance. So that sentence here is a big one, right? You appear to acknowledge that you are or were known by these names, and so I cannot see how you'd be lying when using documentation that reflects you. So the legal fiction is a reflection. And when I'm writing to them, I use the term, I don't use legal fiction, I don't know what it is. I use the term reflection. If they go, what's that? I go, I don't know, ask the Home Secretary. I say nothing that I've invented. The Home Secretary is called a reflection, so I say I'm a reflection. What's that? I don't know. Ask her.
There isn't another word she could have used that would have been better, is there? Because it is a non-thing.
It goes back, I've done a lot of work in that word reflection. It goes back a long way into Roman law and also law of occupation as well, by the way. The occupying power reflects the sovereign power.
Oh.
Give it back next month, I'll give you a talk on law of occupation. I'll knock your socks off, you'll be convinced you're under occupation, right? So, where do we stand? You accept liability and risk for the alleged legal identity whenever you use it. You will start. Do you know what an allegory is? Allegory. An allegory is a song, a play, a written piece of work, a piece of music is written, everything is written down, yeah? Which represents something that's real, but it's not real. So for example, if you tell a fable or a fairy tale, it's not real, but it's telling a story, right? It's representing something that's real, so it's called an allegory. You've heard of the word alleged?
Alleged story.
Alleged means it's an allegory. Right? There's a test case from Canada, there's a test case from Canada where the judge refers to the legal, there's very few test cases, I'm sure there's more, but they've buried them. They're not publicly available, these are buried, right? But I found one from Canada where the judge refers to the legal person as a legal allegory or an allegorical title. So I use that in my letters, it's an allegorical title. What is it? I have no idea, ask him. Right? So I say what I'm doing here all the way through is stating nothing but facts. Facts come when they write letters. So I write letters and I get responses back, and I quote when they respond. To me, that's a fact. Yeah, I don't presume any facts. I quote what they've wrote to me. So this requires you writing a few letters, having a bit of fun, dancing with them, blah blah blah. But ask the questions and make sure you get the answers for them. Right, the 3 tests for trust. Just to show how powerful this is. So a trust is what everybody's scared of. Trust, so secret trusts and all sorts of weird trusts are there, right? To be held as valid, this is case law. To be held as valid, trust instruments would have to have certainty of intention. So that's, for example, if you constitute a company, the constitution is the intention. If we do a little trust between us, the trust agreement is the intention of what's the purpose of the trust. The documents confirm that. Or it can be verbal, you can create a verbal trust agreement, yeah? So it must be certain. Certainty of subject matter. It must be clear what property is part of a trust. So the trust is there to do something with something, right? So you must identify what the subject matter is, clearly and precisely. Certainty of objects. It must be clear who the beneficiaries, the objects of the trust are. Okay? So I can demolish a trust in seconds by, I don't know if I'm not identity or not. In fact, I've got all the documents to prove it. Nothing I've invented. Me writing to the guys on top and asking them questions. I have no idea. So I can demolish any trust by doing that. And in courts, you're aware of courts, they create constructive trusts and resultant trusts. You're aware of it, yeah? Does anyone not understand that? I'll very briefly go over it. A trust in the court. The judge has got to, in a court, they're bringing in the powers of attorney for all the different parties, right? To come and present their cases and argue. Somebody screwed up. So what happens? The senior trustee of the trust, you're the junior trustee, the senior trustee will come in and say, right, answer to it, and I'm going to punish whoever the trustee is that's fallen foul of the rules of the trust. So what the judge will do, there'll be a true constructive trust in the court, so he will actually create a trust for the purposes of holding that court. He can't do it if you challenge the identity of yourself and the other party. And I did this 4 years ago in court with great effect. The judge standing going, yeah. They need to form to court. They can also do a resultant trust. So if the law says, giving you as examples, but if the law says that the court will do the law can create a trust in the court. Again, you can demolish that by removing the certainty of the objects, right? The certainty of the subject as well. Right, Allegro title, covered that. Just little points here, right? Think about yourself. So now you've heard this, you can't say I didn't know, you now know this. Your identity, your go over identity in a second, we'll go stop at that point. So next time you're asked for your title, how do you respond to that? Well, not a lot of people answer this question properly. What is your title? Is it Mr? Mrs?
Master.
We call Master if you want to go down that route. I'm a beneficiary, because a beneficiary needs to know, fuck all.
My title is not what.
Not what.
What's your title?
Yeah,
Ah.
I like that.
Okay, yeah, I mean, it's your personal choice what you use, yeah, it's your personal choice you use. I'll use alleged in front of my name every time you use the legal person name. I put alleged in front of it, and you've no idea how angry they get when you do that. Trust me, they get really angry, because you're alleging that you are Mr. John Smith, Mrs. Jane Smith, right? You're alleging. My missus went to court with it, and the judge went apeshit on her. Are you Mrs. blah 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 blah, allegedly? Non-appearance was the thing, non-appearance. Anyway. Your name, we're there, just alleged. We're not saying yes or no. Your name, your address. I mentioned last week, last month, there's no legal definition of the word address. So the address and title are the same thing. Date of birth, that's pure. The date of birth is entirely hearsay. Entirely hearsay. Because that birth certificate proves nothing. Your profession, your nationality, your identity, right? Never accept presumptions. The lesson here is never, ever, ever accept presumptions. Never create facts. Always present facts which are given to you by people who are legally trained, yeah? Never assume any presumptions. Now, just to very the word identity. This is the kind of boring guy I am. We'll go through all the etymological dictionaries and they'll go through the law and one thing like to find the meaning of words, because words are key to everything. And I've actually started using Gaelic words. You can use Welsh, any indigenous language. I've started using Gaelic words because you don't fall foul of the traps by using Gaelic words. I even spell my name in Gaelic if I don't wish to contract with someone. You're aware that to form agreement, you must express intent. So if somebody says to your name, you go, I'm John Smith. What you've just done, inadvertently, because you don't know the law, right, is you have expressed intent to form agreement. Which is why when I do my talks, I'll generally start by saying my name's Rob. I'm not going to give my second name because I do not wish to form agreement. So I make it express that, right? You can imply it by just giving a name, any name. I spell my name in Gaelic, right? Which is interesting because there's 17 more letters on it, but it confuses them. But I give a name because that is me not expressing intent to contract by doing that. So a French identity, from the old French identity, from late Latin identitas, from Latin idem, the same influence by late Latin. So it comes from East, it goes back to Indo-European roots, all the way through Latin, all the way through French. So the word's not changed, right? Id, the ID. Does anyone know what ID means? Is there any aesthetic people in the room? Right. In Freudian theory, the division of the psyche that's totally unconscious. So they had this unconscious part of you, right? The entity is something that exists as a particular and discrete unit. Persons and corporations are equivalent entities under the law. The fact of the identity is also the fact of existence being. So entity, the fact of existence being. So that's a fact. By being an entity, it's a fact. I'm here. You see it, it's a fact. Yeah. Nobody disagree. I'm not an entity. The existence of something considered a part. So what they're doing is they're creating a trust. And this goes back to the Bible stuff with the Father, Son, and the Holy Spirit. I'm against the Trinity. Absolutely opposed to the Trinity. Because what it does is it creates a trust. Where God is the elector of a trust. And he creates the Vatican, if you're Catholic or whatever, creates the Vatican as a trustee and you're a beneficiary. So you're a dumb. What we do is they bring you as a trustee as well. And once when you go in every Sunday, you're going to have to answer for being a poor trustee, not looking after the person. It creates a trust. So the identity thing goes back to Roman, Vatican, Roman law rules, where it creates a trust where you can be held liable for it. And if you let me come back to the law of occupation, I'll blow your mind apart and start talking post limit post limine is massively important. Anyway, if there's any questions, I'll stop at that. If anyone wants these, by the way, these are free going if anyone wants them. Right, do you want a quick update on the council tax?
Before you go to that, if you can send me them or links to them, I will post it in the underneath so that people can.
Okay. Be careful, guys, because it's frauds. The reason I haven't gone too public is there's a few bits and pieces I haven't disclosed here. I'm aware there's a lot of rogues, let's use this as a word, rogues out there, right, who will use this information, and I have no wish to give people information they will use to cause harm, loss, or whatever to other people, right? So some bits and pieces I haven't shared, there's some documents I won't share with people, right? Because unless it's I know you personally, because I know it can be abused. It can be abused, particularly in the current climate, yeah. So yeah, anyway.
Well, one question about the Gaelic. I was toying with the idea of putting documents into the court in full Gaelic.
Absolutely, yes, absolutely.
Yeah.
What would you think would be their response?
Correct. Absolutely correct. If you want a translator, that's fine. You need to get a good translator. Because in English, Gaelic's a lot more precise than English is.
Yeah.
And Welsh is very precise as well. The language is precise. And under Gaelic, was it Lance? What was it you call yourself again, Lance? What is it you going? Bodenach. It means old man in Gaelic. That's what he calls himself, yeah. Yeah, some good words. For magistrate in Gaelic it means master. I responded back, the only master I've got is my conscience, straight to him. You're not my master. So what they're doing is imposing their conscience on you because they're deemed to be the master. I'm my own master, my own conscience. Right, council tax update, right. Sent away a number of complaints. What I'm doing, building up a case here. So what I do is I want it black and white. I don't want to go in there arguing the particulars of the claim. So what I've done is I've made formal complaints to the Magistrates Court. That's what we've taken on. And the basis of that case I spoke about last month. The case, I'll cite the case as before Mrs Justice Andrews, DBE, on the application of Reverend Paul Nicholson and Tottenham magistrates who are the defendant. So he's took Magistrates Court to court. And interested parties, London Borough of Haringey. And the basis of this was the costs, right? I'm leaving arguing council tax, that's a completely different issue, I'll have fun with that as well. But the costs is a big one. Remember, when they issue a liability order, it's for one sum. Bills Exchange Act, needs to be some certain, yes? Right, needs to be some certain, right? It's not a bill they send, it's a demand. I've got them black and white, I've got them nailed them down now. It's not a bill they're sending, it's a demand. That's why they won't issue invoices, they won't issue receipts, because it's not a bill, it's a demand. Okay, interesting little sidestep. Anyway, so for you to pay an amount, it requires to be a sum certain under Bills of Exchange Act, right? So they've dodged the Bills of Exchange Act, they're inventing crap up, right? So the liability order is the council tax plus the costs plus the court fees. Court fees, £3. It's the Magistrates Court Fees Amendment Order 2014, £3. No argument, bargain, okay? Council tax, later. That's another argument I take separately, right, based upon my conscience. You can deal with my conscience as much as you want. However, the cost is what this deals with. So if you demolish the costs, right, you void the whole liability order, it's voided. I would say you have to go to court, it's right in the court and say it's voided. Anyway, so you've all seen this Magistrates Courts Guide. You all got a copy of this?
Oh, we read it on a daily basis.
Yeah. Right. No. This is the rules. I went to court in September and asked the judge what jurisdiction we're under. What's the rules and procedures? And they went, Magistrates Courts rules. I was, you mean the guide? Oh yeah. Right. So this is what they're working to. Right. So instead of getting to court being shocked and stunned at what they're doing, right, this creates, technically, a duty of care on them because to comply with this, right, and the regulations. However, the judge says what they've not done is comply with the regulations, right. She said that for 3 months, the court, this is why Magistrates Court was taken to court, they had been treating this as a criminal case, and this is where we've got them, guys, right? Magistrates Courts deal in, day out with criminal matters. That's where the process monkeys are comfortable.
They've changed the justice centres now, though. They've changed it from magistrates' courts to justice centres.
Doesn't say that in the regulations.
Yeah.
It's out with the regulations.
She specifically said in that judgment that it was a civil jurisdiction, didn't she?
No, she didn't. She said it's not criminal and it's not civil. And the reason for that is she said criminal is beyond all reasonable doubt, so that's not the level of evidence we're working to. She also says it's not working to a balance of probabilities. It's also not reasonable. It's not what the reasonable amount is. A civil case would be based upon what the reasonable amount is. She says it's not based upon reasonable amount. They're not following CPR, civil or criminal. They're not following these procedures, so it's not civil or criminal, right? But she said it's not based, the test is not to what's reasonable costs. The regulations state quite clearly it's costs reasonably accrued. Same as you submit expenses, you have to give receipts in to prove it. No estimates, you can't say it was an estimate. You try and pay your tax bill based upon estimates, right? So it's the same level of she said you have to go back to regulations, and the regulations say costs reasonably accrued. Okay, so the council, so you need to see those receipts. You can challenge them. I don't agree with that. Somebody says I was on the telephone for 4 hours, prove it. You can have a recorded transcript of it. There's 1,000 things you can do as you would do for expenses if you're giving it to a company. Yeah. Now, interestingly, using the Magistrates Court's fees Amendment Order 2014 for a tenner, you can apply for a copy of the liability order from the court. And what you're doing by giving that tenner, you're creating a contract. So if they fail to provide, it's not the Freedom of Information Act. It's a contract created. So given the tenner, they must provide you a copy of that document. If they don't, one, you've got them in. There's a contract formed. Right? If they do cash a cheque, if they send the cheque back, they're now in breach of their own duty of care, and they're actually breaking the law themselves. And they've said to me, we don't keep the liability orders in the court. Right, okay. But what they did do, lovely people they are, is send me through a thing called an extract of court memorandum. Right, and it lists the liability order. And it lists the case number and defendant. What jurisdiction is that? Criminal. Criminal. This is gross negligence. So what I've done is I've submitted a complaint through. I want this Justice Clerk's head in a fucking block, right? Because it's the weak, again, going back to the levellers, these people, who they're taking on is the weak, the vulnerable, the poor, the destitute, the people who are struggling. It's not the rich and famous that's getting taken on, it's the people who can't afford to pay this exorbitant council tax money. Was paying for all their fancy jaunts abroad and their 200, 300 grand salaries and their chauffeur-driven cars and all that shit that they've got because they think he's the new royalty. No, this is the weak and vulnerable we've been preyed on. Wigan, last year, who's the said the number of council tax? Was it yourself? The number of council tax demands 800. Pocket money. Wigan, last year, 26,000. Sorry, 23,000. Year before that, 26,000 summonses. And we know the shenanigans going on there, it's another story. We know it's financial shenanigans. 26,000 summonses in the borough of 190,000 people. 1 in 8.
115,000 households.
Right? There's real serious financial skullduggery taking place. Where was I going with that? So where was I going before that? I've lost my track of train of thought here. Wigan Council. Oh yeah, and we, through the local paper, got a copy, and I hope the f***ers are watching this. I really hope they're watching this, right? Through the local, because we're going public with this big time. The local paper, they wouldn't answer my feedback, they just refused to respond to my information requests, all yours, because we are part of a local protest group. Human rights, anyone? Discriminating because we're part of a local human rights group. Anyway, silly of them, shows these people are not that bright. But anyway, got the local newspaper to work with us, delighted with this, big story for me. The Guardian's watching us by the moment, they're taking notes on this. And they, was it the 26,000 people last year, 23,000 people we had, oh yeah, and we got a breakdown for the council tax bill, so it's 75 quid, whatever it was, council tax bill, right? It's all based upon estimates. Do you know what money they raised last year in Wigan to cover the cost? Remember the summons, the law, the regulation is from the point of issuance of the summons, which is threepence, to the judge making a decision in the court. So that's the only period of time the cost cover, yeah? That's what the regulations state, and the judge has confirmed that. It's from the point of that summons getting issued, what's the first cost of first class stamp on a bit of paper, right? To the judge making a decision. And she said you're not going to bring in big barristers, this is a simple matter, it's you know, don't need big barristers, so the cost should be reasonable. And Wigan Council sent it through, because the local paper, responded to a freedom of information request with estimates. £1.6 million they raised last year. I'll remind you, this is the weak, the vulnerable, the poor, the struggling. They're financing the whole council tax department in the back of Summonses. Right? We're coming for them. Oh, right, we're coming for them, yeah. So what I'm going to do is start with the complaint process. I'll let them follow the complaint process, because I've got other cases in the back of that, because if they don't follow this complaint process to the absolute letter, I'm going for the people involved in that as well, right? So there's a whole craft. It's negligence. This is criminal negligence. This is downright criminal negligence. You can also go for fraud, whether you get that or not. But I mean, there's a whole raft of. I won't talk too much about what we're doing in that one. Yeah. There's also commercial liens, which I'll be talking to Lance about. So there you go, guys. Right, use the Magistrates Court's Fees Order, Amendment Order 2014. Ask for a copy of the extracted court memorandum and the liability order if you want. Yeah. And if it says case or defendant in there, they'll be the wrong jurisdiction. And Lady Justice Andrews has said it's unlawful doing that. Okay, so have fun.
Just to back that up a little bit, as I understand it, in the court service, there's a bunch of people called the taxing team who are supposed to go through costs awarded with a fine-tooth comb.
Yes.
And say whether they are justified or
yes.
not.
Yes.
And in addition to that, you'll hear judges picking the bones out of applications.
But the duty of care, the Lady Justice Andrews clarifies the duty of care in the judge in the court, or the magistrates if you play magistrates, but it's the duty of care in the judge in the court. For the court, you don't have to ask for this. She says that you don't even have to ask for it, because the court said, we didn't ask for this, we didn't ask for a breakdown. She goes, I don't care. The regulations create a duty of care for you to provide a breakdown.
Exactly.
Of course, reasonable. He doesn't have to ask for it. So the judge then should competently consider. Remember, we've all seen that word consider. The judge should consider. That's what should be considering, is considering the costs.
Yeah.
Okay? I'll go on to, I won't talk about human rights.
I have one more question. You know, we've spoken about challenging people over the ID.
Yeah.
So you send them a letter back saying, can you establish ID when you receive anything
Yeah.
from the post? Off the top of your head, is there a simple wording for that letter?
Yeah, as part of my due diligence, and I'm obliged under law, case law, I require you to provide certified evidence of your identity and capacity in this matter.
Of the addressee?
Yeah, and that's the second letter. My first letter is who you're writing to. What capacity you're writing to me. Yeah, you've got the name, you find out. And what capacity you're writing to me. You're writing to me in a public capacity, private capacity. You're writing to me as a trustee, as a beneficiary, as a partner, as what capacity you're writing to me. Because we presume when they write to us the name, we're presuming who they're writing to. We don't know, because they've all got the same name. So write back and just clarifying, and nobody can find fault with it. Who you're writing to, what capacity you're writing to me. And then the next letter you ask who they are.
And then unsigned. That letter should be unsigned.
You can unsign it or sign it, it's your choice.
Yeah.
And I don't say yours, it's an honour. Equitable.
Rob, any competent person would apply due diligence to this.
That's what you're doing. That's exactly what it says. You're now acting competently and demonstrably acting competent. Is what you're doing now. Because we've all been incompetent and non-competent in the past. You're now starting to act competently. If you say, who are you? That's what a competent person would ask. Because if you go to court and did they ask who you were? No, Muppet. The judge will find against you, it's his fault. He made a Shogun case.
Could you use a saying, like if somebody asks you who you are, say a policeman says, who are you?
Yeah.
You could try and say it's classified information, couldn't you?
Go to you. No, PACE, Police and Criminal Evidence Act. Again, this is stuff I wrote and asked about that. And I was told under the Police and Criminal Evidence Act, you're asked to provide a name. Fine. Doesn't say about capacity. I'll qualify that by giving the capacity as well, right? But also, the word address caused them problems because the Police and Criminal Evidence Act asks for address, but there's no legal definition of the word. So I sought clarification in that.
1966, Rice versus Connolly, appeal court decision. There is no legal obligation to speak to the police or to obey their instructions. That has not been overturned by PACE.
I used to have it in the criminal appeal court next and the judge was great, like if you just listening.
Excellent. Can you just repeat the case again?
The judge looks at it.
Rice versus Connolly, 1966.
Rice versus Connolly,
The
1966.
judge's words were, perfectly good case law, so I like the word perfect, he isn't going to change it.
It's perfected,
and then,
yeah.
And then he basically looked at the prosecution and the CPS and said, you're going to have to change this, I'm not having this. So the charges of obstruction, no insurance and failure to give a specimen were all overturned, so that was a 7-page document.
I'll take those later on myself, I haven't seen that
Right,
one.
there is an exception to that with the Road Traffic Act, where a duty is placed on a driver whilst he's driving to give details to the police, but that's it.
Because, according to what it said there, you have already created a precedent by registering the vehicle under that name.
Yeah, well, you're in the highway
license.
contract.
So,
Well, you
What if it's not
You're taking a license, so you're in the highway
don't bother.
contract. But that's all you have to do.
Yeah.
Provide details, and then...
I spent,
If he says, what you doing, where you going, you say, none of your fucking business.
Yeah.
That's it.
I mean, I can talk with DVLA all the day as well, because I've the letters I get DVLA, they won't engage in no further correspondence with you. First of all, the identity. I hit them with the identity thing. I went into Manchester one day and I picked up 6 parking tickets. That was many years ago, 4 years ago. I picked up 6 parking tickets. They thought it was Christmas. I was stopping next to traffic wardens. Picked up 6 tickets. I went to challenge them on the basis of identity. I don't know. You tell me. And just disappeared. Again, you won't get a letter. I don't get a letter saying, yeah, we're a bunch of shitbags and you win it. You don't get that. There's no winning. I'm there to assist them. I'm not fighting them, right? So I won't get that. All things just go away. I had one road traffic thing, minor one. Again, it's minor stuff, right? Minor one where I was invited to court and I wrote to the judge and I says, sir, this identity thing, I provide them copies of the letter from the Secretary of State, I provided copies of the letters from the General Registry Office. You need to do these letters yourself, guys. Having yourself. These are worth a fortune once you get them done, right? Just ask the questions. And don't big waffly things, you just want straight questions, right? So you can go into a judge and go, I don't know, that's what he says. He's my legal advisor, that's what he says, that's what the Secretary of State says, that's what the General Registry Office say, right? And I say to the judge, if I go in there, sir, the first question you ask is, are you Mr. John Smith? And my response, okay, is, if they're going to step in now as a natural person, can we go into court and demand a mental health assessment on them if they're a natural person?
Yes, because they come up as a psychopath in any test. All corporations...
I don't know, I haven't seen the case law, I'm sure there's been cases on it.
corporation have a mind, Rob?
Oh, by the way, just to go back to the identity thing, right? I've been through case law. There's loads of case law, people tons of it. The internet's full of case law of people proving their identity, trying to prove their identity. I haven't found one case where anyone's trying to disprove that they have no identity. Not one single case. I think there has been cases that have kept him out of the way. I think these are shoved into the back room. There has to be cases on it. There's no cases of anyone disproving their identity.
You can't prove a negative. That's why we have an accusative legal system.
So under European law, specific European law is the one that deals with this thing with transgender, has opened up the can of worms again. But what is it? What is and isn't identity? Is it a man? Is it a woman? Blah blah blah. Right? I'm not going to go into that area. But however, what it does do, it opens up whole. I mean, judges are referring back to previous cases now in European case law, where they're now tripping themselves up. They're now tripping over themselves with the mess they've created. Yeah. It's to do with the identity thing is not certain. It needs a court to give it assumption. Up to that point, it's a presumption. Anyway, I'll leave it at that. Yeah, nice more questions. Thank you.
Debt Free TV, in association with GetOutOfDebtFree.org.